make an exhibit, we have to number 6?
Yes.
And this is some back and forth. What Exhibit 6 is going to be an email between your office and Public Integrity regarding the Senate, the toll records for the senators.
Thank you very much.
Thank you.
Thank you very much.
The relevant, these documents are helpfully not based.
Yeah. If you want to show me yours, I can look for it here.
Okay. This one.
So the department has, if you're going to, has requirements for all prosecutors that, if you're going to bring a tax prosecution, you have to consult with the tax division, right?
Correct.
If you're going to bring a national security related case for classified documents, handling of classified documents, you need the National Security Division to okay that, right?
Correct.
And as it relates to, sensitive political matters, the Attorney General has to okay, and there's been a series of memos, both from Attorney General Barr and Garland and so forth, correct?
Sensitive political matters, I'm not sure if that's the terminology. There's an election year sensitivities memo, and there's also regulations, specific regulations for specific situations, yes.
Right, and the FBI calls it a sensitive investigative matter, and, they need to get they can't do anything without getting the director of the FBI to okay, getting search warrants against members of Congress and so forth, correct?
I'm not as familiar with the FBI regulations as the DOJ regulations.
But is public integrity, before you seek member toll records, is the hoop you have to jump through public integrity?
So it was for my office because I directed my staff to consult them anytime we were going to do that. I understand that was more of a practice and tradition. It's since become a specific requirement after these toll records were issued, but it was my policy to do that, and it was, again, consistent with my policy of wanting to sort of leverage the expertise in the department. So we did that.
Is this back and forth, and your staff had a memo that it, I think, basically put in email, and then public integrity responds with this message. Is that essentially the extent of the back and forth with public integrity?
I don't know that this is the extent of it. There's a line here that says, "As you are aware." That makes me think that there was also a telephone conversation, but I don't. Just to be clear, I don't have a specific recollection of that. I told my staff that in this situation, if we're going to seek these toll records, you need to consult with public integrity. As you can see from the email chain, I wasn't on that email chain.
Were there any other boxes you had to check? Did you have to tell the Attorney General or the DAG to get these toll records, or was it just you and public integrity?
My direction was to for our staff to go to public integrity. It may well have been that this is the sort of thing either I would have briefed the Attorney General on, or J.P. Cooney, who was our contact with the leadership of the department, may have told them about. But the thing that I was most concerned about was making sure public integrity, who was sort of the experts on this issue, that they were consulted.
I mean, this isn't, if you look at the email, it's not that fulsome, right? It's not a complete analysis of the constitutionality or even the propriety of the call record subpoenas under the speech or debate clause. I mean, is that fair to say?
Yes, certainly there could be more analysis, but again, I don't know if there was an additional conversation that it seemed. I'm drawing an inference. I don't recall this, but this seems to me to indicate there may have been an additional conversation.
So the email, from our perspective, it seems to be a cursory litigation risk assessment. It's not, it doesn't raise the issues that we would raise if we were litigating the speech or debate matter. Because, our position is that the toll record subpoenas do violate speech or debate. If you get a list of all the people calling members of the Judiciary Committee before a floor vote, that is pretty core protected material. This back and forth with public integrity doesn't address very much. Is that fair?
Well, again, I don't know if there were additional conversation or conversations. I also don't know, frankly, if this is the only email on this issue. So I don't think I would call it cursory. I think an important context here is that the people involved in this, including the people on this email chain, as well as one of my senior counselors, Ray Hulser, who is really the department's expert on these issues, that these are people with expertise in this area discussing it with one another.
But if you believe what the Washington Post reporters wrote in their book, they say, according to their sources, that you were legendary for being dialed into, every last detail of these cases. That you were, they stopped short of calling you a micromanager, but they say that, you looked at, witness outlines, 2 days before witness interviews. Is that fair?
I did that with outlines of interviews, yes.
And you had, at points, you had daily meetings with the teams, and you wanted to know, every last detail of your case. Is that fair?
I try to be a responsible supervisor, yes.
But when it comes to taking the members of Congress, phone records, you weren't as plugged into that. Is that fair?
No, I don't think that's fair. I spoke with my staff about this. I ultimately approved it.
Right.
I had faith in the expertise of my staff. They discussed it with me. I felt there was a basis for it. I felt it was relevant and material to the investigation. And I also felt comfortable because I knew that my view about that would be tested by an analysis of public integrity.
Well, look at the last sentence. Low likelihood that any of the members listed below would be charged, and the litigation risk would be minimal. Not to mention, they're not going to know. So the assessment is, as Steve described, pretty cursory. We're not going to charge anyone. We're not going to get sued. They're not going to know. Who cares about speech or debate? That's what the assessment looks like to me. Your response?
Chairman, I would disagree with that characterization of it.
Well, that's what the sentence says. We're not going to charge these people. I doubt if they take us to court. It'd be hard for them to take us to court because they're not going to know for years that we did this. Move ahead. And you said fine to that.
I approve these subpoenas, yes.
Okay.
And, our view is this is inconsistent with the DC Circuit case law, which establishes that the speech or debate protections includes a non-disclosure privilege, period. It's not just a privilege against using that material against the members. It's also a privilege against taking that information and using it against a third party. If you're going to prosecute Jeff Clark with Scott Perry's phone records, we believe that the DC Circuit holds you can't do that. And this back and forth with public integrity doesn't factor that in. That's concerning to us. Did you have any discussions with the Office of Legal Counsel or the Solicitor General's office? Were there any other components in the Justice Department that analyzed this?
On this discrete issue, I don't have any recollection of those entities being involved in that discussion.
Okay. And there's a statute regarding Senate phone records. Are you familiar with 2 United States Code 6628?
Yes.
And did you analyze or factor in that statute before you issued the subpoenas for the senator toll records?
As I sit here today, I don't recall specifically discussing that statute. I will say that my reading of that statute as it existed at that time is that that was a statute directed at providers. It actually envisions that a provider might actually get an NDO application, and the provider who has the best information about whose phone line is whose, that they're best situated to make these judgments.
Okay, so that was my next question, is like, whose responsibility it is to flag that there's a statute, a law, that bars NDOs with regards to certain Senate phone numbers? Whose responsibility? Is that the special counsel's office? Is that the carrier? Is that the judge? Does the judge have to sort of figure this out? The magistrate judge? Certainly the magistrate judge doesn't have to figure it out like all on his own, does he?
Well, that statute, as I said, my reading of that statute, the language of that statute as it existed at that time, is that it's the job of the carrier, and to me, that makes sense, because they're the ones who have the best and most accurate information about whose phone lines are whose. They actually have that
Okay.
information.
But the package of materials that you send off to the magistrate judge or the chief judge, whoever the duty judge, as you mentioned, you don't identify that it's a Senate phone number or a member of Congress in those applications. So there'd be no way for the judge to know that there's these additional considerations. Is that fair?
I think that is fair. I think the department guidance on that issue has changed since these events we're talking about. And so
Okay.
now, if one were to do that, you would notify the judge.
Okay, and my time's up, so unfortunately I have